Ms. Hampton, why don't you come have a seat right over here? Mr. McWaters, we got a seat over here. Turn the record on. Yeah, she said she thought the attorney would do it.
Good afternoon.
Good afternoon. You've got a really bright window behind you.
I have not seen this yet, but I hear it's hot. You know what? I should probably do this before I get started because I have so many people to thank. There's so much blame to spread around. Law Nerds Unite, of course. Regeer's Emote Module. Ratman EJ. MGT. And Alyssa. That's a motley crew.
I know. Hold on one sec.
Booty shot.
Well, better than nothing. All right. This is file number 25326 PP. It is a personal protection order the court issued in the matter of Emily Hampton versus A.B. Thomas McWaters Jr. Ms. Hampton is here and Mr. McWaters is here. This case has had a lot of attention paid to it.
I thought it was all right.
I issued the warrant or the PPO back in May. And as I stated on the PPO, I don't usually remove someone from the home with a personal protection order. There was an allegation of sexual assault and threats. As far as I could tell, no criminal charges have ever been made. The defendant denies those allegations, but and there was no lease. So I granted the order. The defendant asked to modify the order, and we had a considerable amount of discussion about trying to allow him to get the remainder of his property off the petitioner's property. And that didn't happen. So through respondent's counsel, Ashley Turner, they filed a motion in order to show cause why Emily Hampton should not be found in contempt for failing to allow the removal of the property. They're asking for attorney fees and any other sanctions the court feels are appropriate. Permission to appear by Zoom because every time she drives here, it's another billable period of time toward Mr. McWaters. So I did allow the Zoom appearance. The parties are here live. Ms. Turner, would you like to speak to your motion?
Thank you, Your Honor. Ashley Turner appearing on behalf of the defendant, respondent, Mr. McWaters. We did have some requests prior to filing this request for a show cause where we asked to modify the PPO or to terminate it based on our belief of Ms. Hampton's lack of reasonable fear of my client and the fact that he needed to retrieve his items. I recall very specifically during the testimony that Ms. Hampton was very clear that she wanted his items removed. She was willing and able to appear at those times that we all agreed on in court. And the exact opposite happened, right? So I think my motion was very clear, is that she explicitly refused access to third parties. Law enforcement had issues with how the order was written. It happened again the second time, issues with how the order was written. Law enforcement, would not enforce the order for his right to remove that property. I think this kind of almost goes back to our original motion to terminate the PPO. This is not the behavior of someone who's in fear of my client, the respondent. She shorted him in, a substantial amount of cash, purposely withheld some of his child's furniture, I think is still in the home. And she's refusing to comply with the order that she consented to under oath. So really, this is actually, to me, a clear example as to what the purpose of show causes are for. And I'd be really interested to hear as to why she shouldn't be held in contempt from her point of view. Thank you, Your Honor.
All right, first thing I'm going to do, Ms. Hampton and Mr. McWatters, will you both raise your right hand? You both swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
Absolutely. Yes, Your Honor.
All right, they are requesting that you be found in contempt. There needs to be an established proof in civil contempt beyond a preponderance of the evidence, and in criminal contempt beyond a reasonable doubt. In criminal contempt, you may well be eligible to have counsel appointed to represent you. I don't, at this point, envision criminal contempt. I envision civil contempt as the sanction if you are found to be in contempt. So I'm not going to appoint counsel.
That's okay. We have time. We can jack this up to criminal. I'm confident.
But you have a right to retain an attorney, which you've chosen not to do. I had hopes that this would be done with, and it wasn't. He contends that they were there ready to pick the property up and you wouldn't let them retrieve it. You were in here. We talked about it. I thought we had an arrangement. They were going to appear at a certain time and recover the property. And as Ms. Turner said you wanted this property off your property. There was a car and some other stuff. What happened?
So they did come to my house. The first time they came, there was no paperwork. I was not the one to call the officers. It was a third party who chose to call the officers. When they came, they said that there was no documentation.
Who's they?
The officers.
Yeah, but you were in here. You were sitting right there and we made this agreement.
Getting their property.
All right. So did you allow them to recover property?
Yes,
All of it?
as much as I could before they called the police on me.
Call the police.
Amos.
He's present, Your Honor.
Yes. All right. So were you there?
Yes.
All right. And they came to recover the property and you were allowing them to recover the property?
Yes.
Then what happened?
They bombarded my door and went through with my son there. They didn't.
What does that mean? Bombarded the door?
My son opened the door and asked them to please wait until my mom got here because I left. It was 10:30 and I went to go to the gas station, come right back. And while I was gone, they came, pushed through the door and my son asked them, can you please wait until my mom comes home to come inside? There's plenty of things outside that they could obtain. Instead, they came in. They started moving things and my son called me crying. When I got
Well, I had an established time that you were supposed to be there, so that wasn't a great
Correct.
time for you to leave in the middle of when they were supposed to
Correct.
get it.
I understand that. Due to the fact that it was 10:30, I wasn't sure, had no documentation of whether, because I left early, I have no idea of whether the dates were changed or what was going on. So I went to the gas station and back. And
Ma'am, are you a whore?
I object to the relevance of that, Your Honor.
All
right, what?
I'll tie it up real quick, Judge.
All right, go ahead.
You're not a whore?
meantime, that had happened. When I got there, I closed the door because my son was very upset, crying hysterically. They got property off of they got his property off of my property, and then called the cops because I told them that they can't go inside right now.
I mean,
My son
those
was
aren't
obviously
mutually
upset.
exclusive.
How old is he?
16. So they continued to get his property off of mine.
Or did they get all of the outside property off the
Yes, I
property?
have documents. I have pictures of all of it. When they called the cops, they said, there is no documentation, so you need to leave. Amos had called AB and
Well, there was an order, but
Yes.
apparently they didn't bring it with them. That order wasn't like filed in the computer, so the police wouldn't have had access to it.
right, so they asked them to leave. They asked me if I wanted them to unload the trailers, and I told them no.
Did they ask you?
No, stop. Who asked you if you wanted to? All
Officers.
right, so you said, no, go ahead and take the stuff you got.
Yes. And they actually stood around for about, I don't know, maybe a half hour or so. And then they said, we don't have time to be standing here. We need to move things. You guys just need to leave. I kept my mouth shut because I didn't have anything to say.
Those they were called and still are called civil standbys, where the cops would come and stand by while there was property being removed. They don't like them. They take a lot of their time, and they're like, we got better things to do than sit here for 2 hours while you remove stuff.
That's
But
exactly what
they
they
did
said.
some of it. So according to what I understood, nothing was removed. So you're saying everything that was outside was obtained.
Pictures to prove that.
Why don't you hand them to the officer?
Your Honor, I
Just a minute.
Okay.
And you're saying some things from the inside were obtained, but then someone called the cops and that stopped.
Yes.
All right. With that, Ms. Turner, what's your contention?
So there were some items from the outside lawn that was able to be removed. However, everything inside the outer buildings had new locks on them, and she would not allow entry into those. And they also did not retrieve everything from inside the home.
All right. There are some ancillary buildings outside of the house, pole barns and other things. So did they get anything out of the pole barns?
Yes, they did. If you look at the barns are wide open.
Well, they appear to be. They're hauling off. I'll get to you in a minute, Mr. McWaters. They're hauling off a 4x4 car body. Some sort of a check stand or something, some furniture, a couch.
There's a whole video with all of them,
Dryer, washer,
except one or two new ones.
freezer, maybe.
Look in the post section. You'll find the video.
1, 2, 3, 4, 5 people in the picture. A car
It's called
full
Songs
of
and the
what
Key
looks
is
appear to be
Stupid.
clothing.
It's fantastic.
The car keys to a GM. Something. Lots of clothing. Dog cage. More stuff packed into an automobile. Looks like medications. And here's a bunch of people kayaking on the river. Not sure what that's about. That may be in there by accident. Would you show those to Mr. McWaters?
That
Now,
reminds me.
what the,
That reminds me of the good old days when somebody patched in on Zoom for a call and they were kayaking. It's such a Michigan play.
show cause petition says? I'll start at paragraph 3. During the hearing on May 28th, petitioner Emily Hamilton was placed under oath and testimony was taken. During that testimony, she testified that she wanted Mr. McWaters' items removed from her barns, home, and property. She continued to be available and willing to allow third parties to remove Mr. McWaters' items on Saturday, May 31st from 9 to 5. Paragraph 4, on May 31st, a group of individuals who were family members of Mr. McWaters came to Ms. Hampton's home. Upon entering the residence, the following items occurred. The parties associated with Mr. McWaters appeared at the home with vehicles, trailers, and towing equipment in order to remove all the items belonging to Mr. McWaters from the property. Ms. Hampton explicitly refused the third party's access to the property. Law enforcement was brought to the scene and law enforcement encouraged Ms. Hampton to allow the property to be removed, but she refused. Law enforcement refused to enforce Mr. McWaters' right to remove the property through the assistance of a third party. Well, that makes it sound like you got nothing out of there and you were refused access to the property. Her sworn testimony with photographs is that you removed a bunch of stuff. She says you took everything from the outside, which makes paragraph 4 disingenuous. Paragraph 5, on June 7th, a group of individuals who were family members of Mr. McWaters came to Ms. Hampton's home. Upon coming to the residence, the following events occurred. The parties associated with Mr. McWaters appeared at the home with vehicles, trailers, towing equipment. Ms. Hampton explicitly refused the third parties to enter the property. Law enforcement was brought to the scene and law enforcement, same thing. Making it sound like you got nothing. So were the pictures that you're showing, are they from May 31st?
There's a few from both.
All right, so they came on May 31st and again on June 7th. What happened on June 7th?
June 7th, I was gardening in my front yard. They came, they wanted to get the rest of the property. I said, that's fine. Like I said, I didn't say anything to anyone. I didn't want to cause any confrontation. Again, the police were called by Amos. And when the officer arrived, she asked me what was going on. I gave her the documentations. She went and talked to the third party. In the documentation, it did say A.B. McWaters, not A.B. McWaters Jr. A.B. McWaters told the cops that his name is Tom. So
He goes by Tom.
mhm.
I still can't get past documentations. I mean, right there, you just lose everything with me.
So she asked them to leave the property because the documentation wasn't correct. She asked me if I wanted them to unload their vehicles again, and I told them no. I was accused of locking all of my barns, which I did not do. There's one lock on one of my barns, and that exact barn has a garage door, sliding garage door he took the foam, well, him and I both took the foam down around it to be able to open it. It is not on the track, so you have to like pull it out and slide it open. It's very difficult to get open. So that's where they're coming at me with, I'm not giving them anything off the shelf, or the red barn. That's inaccurate, but if you can't get it open, to me, I'm not saying anything. You should have spoken to TJ to where he could explain to you how to open it, because I can barely open it.
All right, well, the person that actually Randy M. Monson for the plaintiff, if your testimony is truthful, these petitions aren't accurate. Mr. McWaters, you weren't there. So who was there? Your father,
My father.
who goes by Tom, and Amos Klein
Yes, sir.
is your cousin,
No.
just a friend?
I've divided these pictures out too a little bit.
All right,
This first file here were things that she contacted my ex-wife in the beginning of the PPO issuance to have my belongings removed. That's the Suburban with all the clothes in it and stuff. That was not received on either of those days.
all right, so that Suburban with the clothes in it was not recovered on May 31st?
No,
Where is that?
I have that. My ex-wife brought it to me.
All right, so that's recovered, but not on that day.
Correct. That was way prior to all this.
All right.
I believe it was May
And
13th.
then there's 4 photos here too of a car with the hood open.
Mhm.
If you look in those photos, you'll see my whole wall of tools that I'm trying to get out, and that is in the red barn. You can tell by the metal in this picture that it's the corrugated metal that's seen in this photo.
Well,
and this
why
photo
weren't
as
they able to
well.
get that stuff out?
I was told the door was chained shut with a new lock installed.
Just a minute.
All right.
All right, so did they haul off your 4x4 and that car body and the other stuff?
A 4x4 was removed, a car body was removed, a stand-up freezer, and a engine dolly and the couch. That is it, Your Honor. 1, 2, 3, 4, 5 things.
What is still there?
Every one of my tools, every tool in this picture right here that she supplied us with is still there, to the best of my knowledge.
All right,
All
what
my-
building are they in?
The red barn.
And it has a entry door, a human
It
door?
has a man door and a drive-through door.
All right, and which door was locked with a chain?
I believe I wasn't there.
All right, well,
This is just what I was told as to why they couldn't get in.
all right. Mr. Klein, would you come up to the podium, please? Well, in fact, let's come right here in the witness box. Raise your right hand. You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
Yes, sir.
Have a seat if you would and state your name.
I'm Amos Klein. I'm TJ Sven.
And were you one of the people that went to this property on Lang Road on May 31st to recover property?
I am.
Did you also go back on June 7th?
Yes.
On May 31st, did you call the police?
I did not. TJ's aunt actually called the cops.
All right, who was that?
Debbie.
Rebecca Seacar.
There we go. I'm thinking of Debbie's aunt. Sorry.
All right, I see Amy's dad and some others in the picture. What were you able to recover on May 31st?
Vehicles on the outside, the freezer, the lawnmower. I think we grabbed a couple of the kayaks that were outside. Some of them weren't there that he owns.
Did you recover any property from inside the house?
Half of a couch.
What?
All right, what happened? Were you prevented from, her testimony was her son was there, he was quite upset.
Half a couch?
He wanted her to come back.
We knocked on the door. He came. I told him the situation about how there was a court order to recover TJ's property and stuff like that. And he was like, all right. I was like, can we come in and confirm a few things? Let me call my mom. He let me and his daughter come in to confirm that her dresser was there, the couch was there, and a few other things. He got his mom on the phone and she asked me to leave the house. So I went back outside. She hung up on me and called him right back. Yelling, screaming, grounded him. This is why he was pretty upset and crying. And at that point, Mr. McWaters asked him, well, now that you're in trouble, can we come in and start collecting this thing?
By Mr. McWaters, you're talking about Tom?
Yeah. He said, yeah, sure. He went up to his room. At that point, we went in, grabbed his daughter's dresser and half a couch, and Emily showed up and shut the door behind us. That's all we were able to recover out of the inside on the 31st.
All right, what about the stuff in the red barn?
We've never been able to get any of the doors open. I personally haven't been the guy to check the garage. or barn. He's not here. Brandon's not here. Yeah, we haven't recovered anything really inside.
All right, you don't even know what's in there.
I do know what's in there. I've known TJ for
Okay,
20
so you've
years.
seen what's in the barn.
Yeah, I've used the tools with him on the cars in the barn, so. I helped him move half that stuff in there.
Did you try to open the sliding door?
It didn't budge. With officers present, I'm not trying to force my way inside anybody's property while they're
And,
pretty much telling us
and-
no.
Was it locked with a chain?
From the inside, I think so. It was tied with a wire or a chain or something. The entry door, the man door, was padlocked. We don't have the keys for it. We can't just cut locks off without permission.
All right, what happened then? So at some point you took the property you had left.
Yeah. The cops wanted us to leave. She didn't want us there. We didn't want anybody getting arrested for just, trying to grab somebody's stuff. So we left.
All right, tell me about what happened when you put back on June 7th.
I really don't even remember what we recovered. I don't think we got anything. She didn't let us inside. I think we grabbed. I don't really remember what we grabbed. I don't feel like we got anything outside. What were the pictures of?
All right, well, I'll get to that in a minute. All right, so, the petition makes it sound
This guy is a shockingly reasonable witness.
like they didn't get anything. She makes it sound like they got everything. So the truth is usually somewhere in the middle. And I'm disappointed that we didn't accomplish this. So these two people wouldn't have to deal with each other. All right. Were you able to get into the red barn on the 7th?
No.
Trying to raise some hard love.
No key to the lock. No, we're enforcing entry. Officer asked us to leave. Take what we were able to get, which is probably only a few things. I feel we got something that day. What is that?
Ms. Turner, do you have any questions for Mr. Klein?
What?
No, not at this time,
Maria's not a new member. What is this? This is insanity.
Your Honor.
All right, Mr. Klein, you can step down. Tom A.B. McWater Sr., would you come forward, please? You please raise your right hand. You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
Yes, sir.
All right, have a seat and state your name for the record, please.
A.B. Thomas McWater Sr.
You go by Tom.
Yes, sir.
Were you present at this property on Lang Road on May 31st?
Yes, sir, I was.
We heard the testimony of Amos Klein about the things that were recovered. You have to speak your answer.
Yes.
All right, so you heard what he said. Do you agree with what you recovered that day?
Yes, we didn't get the car that day. We got that on June 7th or whatever. but-
Well, what happened on the 31st that prohibited you from recovering the remainder of the property?
Well, when we got there, she wasn't there. The son answered the door. Amos talked to him. He let us in. I walked in, I guess what was TJ's room. I ended up walking back out and then, so I don't know what they got out of the house. Then he called her son, he called Emily. And she told me she was upset. So we were all supposed to leave out of there. And then he was upset because he was getting grounded for letting us do what we were there to do. So then I asked him if it was all right to enter the house since he was already grounded. And he said, sure, and took off. And I turned around and went outside towards the barns. And Amos and everybody else that was there to help in the house went in. And I seen parts of the couches and the dresser and the freezer.
All right. Did you know that your son had a large number of tools inside that red barn?
I know he told me yes.
Did you ever been in it?
No, sir.
Did you try to get in it?
Yes, sir. It was shut with a cable, wire cable, and a lock, and the entry door was locked. It needed a key, I guess.
When you
And I
say
had bolt cutters, but I
that was
thought it was probably not wise to use them.
that was probably wise. You get smarter when you get older.
Yes, sir.
So you're saying that the sliding door was locked with a cable and a lock?
Yes, the cable was on the inside and the lock was on the outside.
Did you ever ask Miss Hampton to unlock the door?
Oh, she wasn't going to.
Yeah. She wanted you to leave. All right. Now, what about going back on June 7th?
On June 7th, we showed up. That's when we got the car frame. I think maybe his lawnmower that was apparently missing a couple parts. We wasn't able to get a lot before
So
there was a
what stopped it
discrepancy
on
with the senior junior.
whether you were?
Yeah, because I same name, just it didn't say senior. or
So
junior.
who was the discrepancy with? The police?
Hampton and place, yes.
Oh, she wouldn't do it because,
Yes, no, she was the one probably pointed it all out.
well, it was supposed to be third-party agents, and that's what you guys were. Anyway, you weren't able to get in the red barn on that day.
No, sir.
Ms. Turner, do you have any questions for Mr. McWater Senior?
I do, if you don't mind, Your Honor.
No, go ahead.
Mr. McWater Senior, were there any other areas that you needed to access besides the red barn and inside the house?
As far as I know, everything else was gotten that was outside, just not in the red barn and whatever he had in the house.
Thank you. In regards to June 7th, when you arrived, was Miss Hampton present?
Yes.
Okay. Did she ever come out and speak to any of you?
She came out and spoke to someone, yes. Wasn't me.
Were you asked to leave at that point?
After the police had showed up, then we were asked to. We was able to finish loading up the car frame, the Pontiac, and the lawnmower. Whatever was loaded, that's what we got. Again, no
Okay.
access to the house or to the red.
All right. Thank you, Mr. McWaters. No further questions, Your Honor.
Ms. Hampton, do you have any questions for Mr. McWaters?
Well, I'm wondering why you're telling me or stating that I was the one that wouldn't allow you guys in. I didn't speak to anyone. Nobody. I sat there and gardened the entire time. And every piece of the property that was in my home that belonged to him was on the front porch.
Again, I didn't go in the house.
All right.
Well, Amos and Brandon are the ones that moved the couch off the front porch. The freezer, the dryer, they moved that as well. They didn't move the lawnmower on that day. They moved it on the first time.
Well, and again, this is stuff you wanted off the property. Mr. McWaters, you can go have a seat. All right, so.
Your Honor?
Julie.
Oh.
Yes?
I was going to ask if I was going to get an opportunity to ask questions of the petitioner.
All right, I'm sorry. Please resume your seat. She got more questions for you.
No. The petitioner, Ms. Hampton.
Yeah, I'm gonna ask her some questions too, but
Okay.
why don't, go ahead, and you ask.
Okay. Ms. Hampton, in regards to June 7th, you said you were out in the garden at the time when individuals arrived.
Yes,
Did you speak to anybody when they arrived?
I did not speak to anyone when they arrived.
Did you speak to anyone later on?
As they were leaving, after the police got there and they were loading up the couch, because I still allowed them to take the belongings after the police got there and told them to leave. I said, Brandon and Kyle, which is the third party that I know, They asked me how I was doing, said the best I can. Just small talk, and that was it. Those are the only
Did you
people I
ever
spoke.
did you ever interact with the police officers that day?
Yes,
Okay. What did you discuss with the police officers?
I showed them the restraining order and the documentation.
When you say documentation, are you referring to the court order that allowed my client to retrieve property?
Yes, ma'am.
Okay. And when you showed them that, did you mention that you had agreed in court to allow him to be there that day?
Yes, ma'am. Had I not,
And
he
yet,
wouldn't
so,
have that he took with him.
sorry, what was that?
I said, had I not, he wouldn't have any property that he took with him.
Well, I'm
The third.
wondering, Ms. Hampton, why the police asked him to leave if you confirmed that he was allowed to be there.
I am not the police officer. I cannot answer that. You can ask the officer that.
Do you know who called the police on June 7th?
If I'm not mistaken, it was Amos.
Did you at any point tell Amos that you didn't want him on the property?
No, ma'am.
Did you at any point tell the police officers that they could stay on the property?
I told them they could retrieve the things that they were getting. Yes, even after the officer came, I still allowed them to take the stuff that was on the porch and the stuff, and the dryer and the freezer that was next to the house. I removed all the property outside, therefore there was no reason to go inside. As a matter of fact, I was in contact with the mother of his child, and she came to
Ms.
my home.
Hampton, Ms. Hampton, I'm going to interrupt you as your answer's being non-responsive to my question.
Just try to
So-
answer. Sure.
So was the Red Barn locked when the third parties came on June 7th?
The door was, the barn, I can't even move. I could have told him how to do it, but I refused to speak because I'm not trying to have any more confrontation than what I already have.
Okay, so were you aware that my client had items in the Red Barn?
Yes, ma'am.
So why didn't you give them access to inside of the Red Barn? Why was it locked?
There was access because they could not get in. It was not, that doesn't concern me. He should have, the AV should have let them know how to open that, and then they could have went from there.
So they should have cut the lock, the chain is what you're saying.
No, ma'am, what I'm saying is that the door is not on track. You have to pull it out, push it, and have amount of force to push it. I can barely get it open just to slide through.
Knowing that it's difficult to move that door, why didn't you unlock the second door?
Because I have property in there for my pool. I have my sister's property. I have my friend's property, all in that side of the barn. There was no reason for them to go in that side.
No further questions.
That's
Your Honor.
stop. That's really weak. I resent even being here. This should have been accomplished on the 31st, should have been accomplished on the 7th. Your smug attitude about it's not my problem means we have to even be here. The most valuable stuff that was there is probably the side-by-side and the tools. An old dresser, an old couch. I wish that, I don't know, I'm not sure why Mr. Klein called the police. I didn't ask him on either occasion. Not my problem. It's like, yes, it is your problem. I had a court order that he'd be allowed to come remove the property.
Fair enough.
And so now we're dinking around with this.
Your Honor, this is my daughter's bed.
Yeah,
These are the tools that I make a living with.
yes, don't worry. It's not your turn to testify.
Sorry.
All right, I'll let Ms. Turner finish with Ms. Hampton if you have further
You're-
questions.
No, I had to stop there, Your Honor. I think I've made my point.
All right. Mr. McWathers, what is still there that belongs to you that you wish to recover?
That's not my dryer in the picture. I'd like my daughter's bed. I'd like the 70-inch TV.
Where's your daughter's bed?
As far as I know, it's still in the house, in their bedroom. It was the first day they went. They weren't allowed inside the second day, I don't think. I need my tools. I need my personal effects.
All right, tell me about what we're talking about, tools.
Tools. Probably 100 screwdrivers, probably 150 box end wrenches, a pile of pneumatic tools as far as impacts, grinders, sanders, pneumatic wrenches, ratchets, a big black standing toolbox that's chest high on me. I have a yellow one from Harbor Freight that's mid to the bottom of my ribs high on me.
Right, and all that stuff is in the red barn.
All that stuff is in the red barn, Your Honor, as seen in photos she provided.
I have no use
All
for
right,
the
well,
tools.
I don't disagree. There's a euphemism for ugly, petty divorces. It's called people are arguing about the Tupperware. They're arguing over the Tupperware.
But Your
The
Honor,
stuff in the house is Tupperware.
yes.
Your tools are valuable. She has no use for them. She wants to get rid of them. Her attitude is, hey, not my problem. They're asking you to pay $1,500 for them having to come here and have this hearing.
Honor, can I
Yes,
say something?
yes,
This PPO is because I got raped.
I
I've been
understand.
traumatized. I've had to have therapy. I'm going through a lot. I'm scared for myself and my child. And now it has become into an itemized, I want my belongings,
Yes,
completely disregarding the initial reason that we were in this.
and I
And
authorized
I'm
it.
sorry.
I
that
authorized the
sent-
PPO because of the allegation of sexual assault. Apparently, I was never charged, so there's no criminal charge. I don't know what happened to that.
Okay.
So that's your contention. All I'm trying to do is separate the two of you so I don't have to have any contact with each other. And you knew what was in there, thousands of dollars worth of tools that he wants to get out of there. And they made two efforts to do it and weren't able to accomplish it. Yes?
The reason why I feel like I shouldn't have to open up the door and do all these things for them is because I have gone through so much. Why do I have to assist them? Why is that something that I should have to do when I'm already dealing with trauma? I'm already trying to cooperate. The cops are being called. It's being intrusive on top of it. I'm a little frustrated, yes. So if you do think that I have a bad demeanor, I do apologize for that. But at this time, I'm going through a lot. And for me to assist them, I've already done enough. When I packed up all of his belongings into the car, I moved out all the belongings in my home. I let his ex-wife walk through my home and get everything that Taylor belongs, all of her, everything. And I have text message to prove that. I have nothing that I don't want any of this stuff.
I know.
Well,
That's
also-
why I wish you would help facilitate him removing the stuff. We wouldn't be here. There wouldn't be any more reason to argue about it. There wouldn't be any more reason to poke at this scab.
And I understand that, and I agree with you, but when I'm being bombarded by 6 men and they are all wanting me to open this door for them or do whatever, let them in the home or whatever they're asking me to, I'm feeling threatened. I just got raped by this
You
man.
agreed to it. You
I
agreed.
did, and you're right.
You agreed
I
that
also-
third-party people could come remove this stuff. Some of
Absolutely.
it's heavy.
So what I'm saying is, had they not called the police, maybe we could have gotten somewhere, but instead it was an aggressive and calling the police on me. I can't go, what am I supposed to do when the cops get there? I
Well,
told them they can take the belongings that they had. The officers don't want to stay there and watch them move things. I can barely open that barn door. He's the one that can open it. I'm sure you are aware with Monty and his barns. They're not.
Barney's rinky-dink operations.
Thank you. Yes. And it is hard to open that door. Like I said, I can physically open it about this big. Yes, his belongings are in there. Absolutely. he can get all of those belongings, but I'm not going to assist with this.
This is the matter of Tawana Bell versus Westminster Park, 2501.
Well, there you go. It was going off the rails. Apparently they just pulled the stream at that point. I don't know what I can say. I think I probably shouldn't say anything. Let's carry on.
11135.
Well, Your Honor, I'll put my appearance on the record. However, we are the defendant and counter plaintiff. So, Attorney Sandra Kuzi on behalf of Westminster Park as the defendant / counter plaintiff.
Ms. Cozy, good morning, and you are Ms. Bell?
Yes.
Ms. Bell, raise your right hand. You solemnly swear affirm, tell the truth, whole truth, nothing but the truth, shall be guide?
I affirm.
And Ms. Cozy, have you discussed this and resolved this?
No, Your Honor. We did speak in a breakout room. However, there was no resolution. So we are proceeding on this matter. However, I do want to advise the court that we did file a motion with the court to reopen discovery and to adjourn the trial and to extend the scheduling order. And do want to confirm that the court did receive that. And if we can have that heard before, I know the bench trial is also scheduled today per the scheduling order that Judge Slavin did issue out. However, the motion we would request to be heard before, and we can
I'm Team Cozy all the way here.
put that on the record and go forward from there.
You go, girl.
Just one moment.
No, I did not see that. Let me look.
And Ms. Bell,
Yes.
do you have any objections to reopening discovery in this matter?
I have no idea what that means, sir.
Okay, can you explain that, Ms. Cozy?
I'm sorry, I did try to speak to you in a breakout room. We weren't able to really discuss it. I can go ahead and just, I did advise her that I did try to explain the motion to her, indicating that we were trying to move forward with, reopening discovery given the address change. And I did advise her that we did issue out discovery for interrogatories, request for admission.
This is just weird. She was taken aback just like I would have been. The judge is like, hey, can you please explain the discovery process to your opponent? I suppose it's not my job, but I'll try. We want more information. That's it.
Request for admissions and production of documents. So I did advise her of that. However, as she stated, she does not understand that, and we would just request that we would be able to go ahead and open it again.
Did you understand that, Ms. Bell?
Well, I'm interested in finding out what Miss Scusi is offering.
Okay, is she altered? Is she drunk or on drugs, or is she literally that stupid? That was my first question. Let your boys weigh in with she's high. Yeah, I it's hard to tell with a lot of these people.
As I explained to her before, the method of mailing that she used, proof of service, it didn't go through the mail. The certified receipt proof that I added it was never filled out, meaning it has to be filled out and given to a clerk in order for it to go through the mail system. Miss Kuzi did not, as listed in her discovery, she did not provide any proof of an actual eviction notice stating the date and time by the move. You must be moved out by a certain date. I never received.
I'm getting Subsit vibes, but she's literally so incoherent. I can't figure it out. You guys tell me.
An eviction notice saying you must be out by this date.
Anything else you want to add, Ms. Posey?
Yes, Your Honor. Initially, this goes back way back. So, Your Honor, she did file an affidavit and claim, small claims. Our office did remove it and a general civil. The matter was set for a initial pretrial conference with Judge Shackelford on
So
March.
you say the eviction was removed?
Your Honor.
B, it's not your turn. That's not how this works. It's not how this works.
She filed there was a pretrial conference in front of Judge Shackelford in March. However, at that time, Judge Shackelford did recuse herself of the case. So we could not proceed with the pretrial conference that day. And it was then handed over to Judge Slavin, which at that point we did get a scheduling order, and that just provided us the dates that we had to comply with and along with today's bench trial. So there was not a settlement conference before then. Additionally, the affidavit and claim filed by Ms. Felt, the reasons for the case that was filed in her claim in paragraph 9, she just states that illegal eviction on January 7, 2025 at around 12:30 p.m. So plaintiff doesn't.
Okay, I just want to help her. I can't help it. She makes sense. She's a decent attorney, but she looks scared. It just triggers that instinct. Look, let me help you out here.
So our office does not have additional information about what her claim is. It's a failure to state a complaint initially. We did. So she is initially bringing up, I believe, issues regarding to a non-payment of rent case that we had in front of Judge Shackelford, which was a final order. A judgment was entered. An order of eviction was also entered and executed. So that is what we have initially, the not payment, and I believe that's what she's referring to. So that was.
No, I am referring to
Ma'am, the claim that she filed does not say the claim, besides that illegal eviction on around January 7th. So she is just stating the allegations, but we would request that we request entry of the motion, which will allow us to reopen discovery, allow us to continue to try to communicate with her, and we would be filing a motion for summary disposition.
Did you provide a eviction notice to the court? Did you provide a copy of the eviction notice stating that I had to be out of 10826 Pine Street by a certain date?
All right. Upon reviewing the file here and the
I do like that though. That's subtle, but I absolutely love how she handled that. I'll give her. First of all, she made sense the whole time. She just sounded nervous for no reason. She's crushing this moron. Well, I don't know what you're nervous about, but right there, she did something that was really good, which is this woman interrupted her and asked her a question. She has no freaking right to a response. She just didn't acknowledge it at all, which was perfectly appropriate.
Arguments, the court finds it's in the best interest of justice to grant the motion here. Purpose of discovery is in the hopes of resolving cases. With additional discovery, it's possible the case can be resolved. So having said that, it is the order of the court that Westminster Park motion be granted, and discovery, this is on both sides, discovery on both sides is reopened for 60 days from today's date, the date of this order. The non-jury trial is adjourned to a new date to be set by the court, and the scheduling order is hereby extended, and the court will issue a new scheduling order
But you're not old enough to know that.
which you'll get in the mail. And hopefully you'll be able to resolve this case. You each have a good day. Good day. You'll get a copy of the order in the mail.
This one here is Alyssa's fault. If you want to weigh in right now, here she is.
Can the eviction order be lifted? Because I need to find a place to go, and I can't find a place to go with eviction on my record.
Oh, that sucks for you. Maybe you should pay your rent, not be a jerk.
Yeah, we're not addressing that at this time.
Your Honor,
You each have a good day.
Your Honor, if I may, just request in regarding to the motion, we would just, Your Honor, I would just request that we be able to schedule a pre-trial conference before the date that the trial is scheduled.
1 second.
A perfectly reasonable idea. We find out right here what she's trying to do. First of all, she knows this is BS, and she'll show up unprepared and asking for other stuff. Number one. Number two, she's trying to get a date so that she can present a motion for summary judgment and dispose of this pretrial, which makes all the sense in the world.
I'm going to add language that in the new scheduling order, there'll also, prior to trial, be a final pretrial conference.
Thank you, Your Honor. And to confirm, the scheduling order will provide us the dates for motion, deadlines, and witness and exhibit list, because we do intend to proceed with a motion for summary disposition.
So I'd like to ask Ms. Kuzi again, the reasoning for her derogatory statements that she made in her discovery that she submitted to the courts.
We can put you in a breakout room.
Right.
Ask you that.
Well, I asked her that.
This judge he generally makes sense, but he says some odd stuff like that, like, oh, we can put you in a breakout room so you guys can bicker with each other. No, I don't owe her a conversation outside of your presence, Judge. You can see she's a kook. We're not working it out in a breakout room. I can show you how that breakout room would go, at least if I was involved. She'd go, why, she'd yammer something at me, and I would say, pound sand. All right, we're done.
Record, and I asked her in a breakout room, and she didn't respond to me. So I want to ask her in front of you why she wrote all these derogatory statements about me, which are not true.
You care to answer that, Ms. Cooley?
No, Your Honor. She's just making these allegations. Just trying to speak in a breakout room.
These are not allegations.
I would just request that the trial be held, and we'll wait for the order.
You each have a good day.
Thank you, Your Honor.
For a final pre-trial conference, I know that there's another case that we dealt with, and that is versus Tiffany Jacobson, in which the people have requested to consolidate one of these.
This is MGT. I haven't seen
that. That would be file 3614. But we're going to postpone that, and let's see what we're doing. Do we have any resolution to either one of the two cases? Mr.
No, Your Honor.
Thank you. All right, Mr. Ringstrom, that means that we are able to go to trial on 3614.
3614 would be the file that we filed a motion to.
3619.
So 3619 would be the one that
Right.
be stuck.
Thank you very much. Yes, sir.
Your Honor, I did file a motion this morning asking for a motion to adjourn the trial date.
Sure. Let me see it.
That's actually one first.
And we're talking 36.
I have 1,
19.
1, 4, and 3619. I'm sure one of them would have been
3614 is adjourned. You know that one. So I'm going to make a note. 3614 is adjourned because we have a motion to consolidate with the People versus Tiffany Jacobson. 3606. Now let's take a look here at the motion to adjourn the trial date. All right, I'm thumbing through the file looking for some information, and I've come across the prosecutor's objection to the defendant's second discovery request. Was that ever set for a hearing? That was filed there on June 23rd.
It was never set for a hearing, Your Honor.
Okay.
At the time, the objection in there informed Mr. Dick that if he had any specific objections going forward, we can go and argue this motion, but he has not said anything about the issue of discovery.
All right, I don't need to address anything there.
There is, I assume the court had noticed there should be a prosecutor's motion to quash his name on defendant's witness list.
Yeah, I got that. We'll deal with that in just a second. Okay. All right. So I'm going to take a moment here as I continue to review the defendant's motion to adjourn the trial date. Actually, you know what's going on with the transcript? We dealt with this a little while ago with the person who left and said they were going to do it, but of course failed to do it and never did it. You know whether or not Linda's supposed to assign
I don't
those
know
to somebody
who
else.
got hers. I know I got quite a few of them yesterday.
All right, we'll look into the transcript for this one.
Your Honor.
Yeah.
I did speak with Heather in the district court office this morning, and I guess she has been assigned.
Oh, okay, then she has been assigned. All right.
Okay.
All right, so thank you. All right, and so what, besides just getting the transcript for testimony and cross-examination, is there some other reason, any other motion that would come out of the transcript? Did you handle the preliminary exam?
I did, Your Honor.
Okay,
Yes.
so is there something in there that you think is necessary for a motion?
So the only other thing, your scheduling order, Your Honor, says that the witness list has to be filed at least 28 days before the trial date, and only it can be amended with the court. So there's potentially additional witnesses that might have been mentioned in there that I don't have their names at the present.
Okay.
So I would need that to add.
All right. Well, that I can always do a workaround and get you a recording of it and allow you to have access to that while they're still preparing the transcript. All right, so the next question here is, there's something here, you're requesting to complete DNA testing of evidence. What evidence needs to be tested for DNA?
So, Your Honor, the DNA evidence would be a urine sample.
Okay. And she's got a charge here of possession.
Yes.
So was there, hold on a second, Mr. Rickster, why don't you tell me what the nature of the possession is?
You people don't know what I'm dealing with. Food Fairy's got some shenanigans planned. So I'm trying to be good, but I did have to crack one of these.
For this file, actually, we have her on delivery of, not to be wrong, controls of delivery.
Okay, hold on. I thought I was looking at. Oh, that's 319. That one. I should just keep this over. Yep, okay. I was looking at the wrong one. All right. So we've got a delivery.
That reminds me of that douche tool who had the urine love license plate, who's a urologist. Oh, good Lord.
R&O and contraband into the jail, and then a tampering with evidence. So where does urine come in? Is the allegation that she swallowed it and then that's why you need P?
The allegations would consist of, I believe, I don't want to speak for Mr. Lake, but I believe where he is coming from is urine samples that were taken from other inmates in the jail that had said that she had delivered meth to her. There was a urine sample that was done. I don't think that we have any more urine samples. I'm not exactly sure which he's talking about as far as it goes, because we had a blood draw. So
what urine samples?
So they would have been the initial drug test at the jail, Your Honor.
So do you know if they kept the urine?
I'm not 100% sure at this point in time, Your Honor. I was going to ask the court.
I do not believe they kept that,
Your Honor. So
So do the people intend to offer any evidence
We
of
did not.
urine tests?
No, Your Honor, we do not.
Are there blood tests from these individuals?
There was blood tests that were done, a blood draw was done at the hospital, and then they were there. We had it tested, and I'm trying to come up with a chain of custody. I thought that they destroyed it afterwards, but I'm not sure.
Hold on. Let me see if I can catch this correctly. The alleged delivery occurred allegedly in the jail.
Yes.
And some of the witnesses that the people have listed must be the other inmates.
Yes, sir.
And those other inmates may have tested positive for methamphetamine, correct?
Yes, sir.
And that would be used to corroborate whether or not they did or didn't, or whatever their testimony is, whether or not they received it from the defendant allegedly.
Yes, sir.
Okay, and so was there P tests done?
Originally, my understanding was there were P tests that were done, but based off of the P tests, they wound up going to get the blood samples.
So it's the same thing as a preliminary breath test. So they then went and got a blood draw, and those blood draws allegedly report that they had methamphetamine or didn't have it in their system.
Yes,
Either
sir.
one of the two. All
Yes,
right.
sir.
So,
I can make the connection.
yeah, go ahead.
Your Honor, so the one of the allegations that kind of sparked this whole issue was that there was urine given by one of the inmates to my client to like circumvent a drug test.
Right.
The drug test that was taken came back dirty.
Okay.
And the urine sample, if we were.
Was it the urine sample from her allegedly?
The alleged urine sample.
So someone else in the jail allegedly gave her urine that she could use to circumvent the test.
Yes, Your Honor.
And that alleged urine was tested positive anyways. Right?
Yes, Your Honor. That's
okay.
That's
so
you just can't trust other people in the jail to give you a clean sample. Where's the where's the loyalty there?
All right, so you want to determine the DNA of this urine.
Yes.
Of that urine, not the other urine.
And the unit, the small bottle that's in, I believe is labeled present People's Exhibit 4, that had the means of giving the urine to my client.
Is she charged with testing positive?
No, Your Honor. However,
okay.
If this urine that tested positive is the same urine that was in this bottle, it would provide at least some reasonable doubt that my client had supplied.
How does it apply reasonable doubt? If that witness, do you know who gave her, do you know who allegedly gave her the urine?
Yes.
All right, so you can ask that person if they gave her the urine.
Yes.
And do we know have they been asked that question?
Yes.
And do they admit it?
Yes. However.
Okay.
they also had said that they had never tested positive, or should not have tested positive because they hadn't taken anything before receiving the methamphetamine from the clinic. So,
And is that person one of the ones that claims she delivered it to?
Yes, Your Honor.
Okay. All right.
and if the DNA, if we're able to obtain the original P sample and compare that DNA to what was in the little bottle, that if they match, that would also be compared against my client's DNA, which would show that the positive test was not her. So that would
But she's
demonstrate.
not charged with testing positive.
Right, so the timeline of everything suggests that the urine was provided before the fake urine or urine that was provided to circumvent the drug testing was provided before the methamphetamine was given. Now, if that urine actually tested positive, then that person likely or must have had the methamphetamine before she gave the urine sample to my client.
Before what?
Before
you got to stop talking proper. You got to figure out your argument, because I don't think you even know your argument. So she tests positive for urine using someone else's pee, and they obviously had used methamphetamine, therefore it caused them to test positive. But they have somehow said they never tested positive.
They said that they couldn't have tested positive at the time they gave my client the urine.
Okay, but does that person now testify that she gave them methamphetamine at some time?
Yes, Your Honor. If I may.
Yeah.
Try and clear up the facts, what is, I believe Mr. Dick is arguing is we have a situation where one of the inmates admits that Miss White had wound up giving her urine. She admitted that she gave Miss White urine in a plastic bottle. And that's what I think Mr. Dick is talking about, is this plastic bottle. That tests did allegedly come back positive for meth, which Molly White claims.
How was it tested? In a lab or with the dipstick?
It was just tested at
the jail.
It was just tested at the jail. So what Mr. Dick is saying is he wants it tested to be able to show that maybe it's Randy, the other inmates.
Seriously? We have to have a Mr. Dick in this?
DNA that's in that bottle that supposedly tested positive. The other inmate definitely did admit that she wound up putting the urine in the bottle for Molly White, but had indicated that she has no idea how that could have come back positive because she had not used beforehand.
Okay.
I don't know where the DNA
But
comes
she's
in.
not, but Miss White isn't charged at all with anything about the urine bottle.
No, I believe what Mr. Dick is trying.
What the hell where is this guy going? My client used somebody else's urine. It was positive. Now I'm going to use the hearsay testimony of an inmate to say she really just doesn't understand why that's positive because she didn't use. Oh my God. It's not helpful in any way. It's inculpatory. And it's stupid. And it makes you have a discussion about P and Mr. Dick.
To argue is that the other inmate would have been tested positive for meth before acknowledging she was in receipt.
So in other words, the P tested positive for meth that she got from somebody else other than her.
Prior to that, yes.
Okay. Because she couldn't have gotten meth from any other person. And did you find out how long she'd been in jail? Had she been in jail without a period of time for it to clear her system?
Well, I believe she had been in custody since sometime.
You gotta stop this believing and putting together a timeline that.
Yeah, like I don't do criminal defense, but if I was here, I it's hard for me to judge. But if I was here, I'm like, I'm just not. This isn't going to help us. even if it's true, let's say she used somebody else's urine and the test was a false positive. I would literally tell my client, I don't care. I don't want to walk through this minefield. It sounds worse than anything you're currently accused of.
You can't put together and try to explain it. So let's get back to the very first question. Is there any urine to go test?
I do not believe that there would be any urine to be able to test. I think Mr. Dick is trying to argue he wants DNA testing on the plastic bottle that was used.
Is the bottle still here?
Yes.
Okay. So we're not testing urine, we're testing for remnants of DNA inside that particular bottle. Okay.
If the urine samples are available, Your Honor, I was seeking to obtain at this time. And I don't know 100% that they are or not, but
or not what?
That they are still available, or if they are not still available.
He said they are.
The bottle is, I know the bottle is, as far as the urine sample goes, Your Honor, this is the first time I've ever been requested as far as the urine samples go. I did not check. I'm pretty sure they destroyed them and got rid of them. If it does matter, I could go back and check with the jail right now as far as it.
You all can set this for a hearing and you're going to set it sometime next week. Okay. This is a motion that has nothing to do with the transcript. Should have been brought up a long time ago. And I'm going to tell you, you better in your motion, or if you want to redo yours, you better give me a timeline that tells me when all these people were inside the jail. In other words, all the people that allege that they got the substance from her, when did they get to jail? How long have they been sitting there? When were their last, did they have any other blood tests or urine tests? I mean, you got to figure all that out. This argument is put together like, I don't know, grabbing a handful of sand and dropping it on a plate. It's guessing, and you shouldn't be guessing at this stage.
This argument is almost as bad as that analogy, Judge.
So I'm not going to adjourn any trial until I have a motion or give me a reason for it. So far, I don't have necessarily a reason for it. Plus, this is not set for a hearing today. So you guys can deal with that, file it and get it on the docket. All right, so now I've got to deal with Mr. Ringstrom. We have to deal with Mr. Ringstrom's motion. Mr. Ringstrom, you were listed on a witness list in file 3619. That's the same file we were just talking about. Is that right?
I was also listed on the other file as well, Your Honor.
All right. Why is he listed as a witness?
It was because of something that happened during the preliminary exam, Your Honor.
What happened during the prelim?
I had told a witness that the people had subpoenaed to testify on our behalf.
Okay.
Mr. Ringstrom kind of lost his cool and told the witness that if he testifies for the defense, he will revoke his immunity. And the reason that he's on both of those is that, again, I don't have the transcript because I need that for.
Was this done on the record?
Yes.
Okay. Did Mr. Ringstrom, before you put a witness on the stand, did he make a statement?
The witness had made a statement through a police report.
Gotcha, that's what I expect. So during the prelim, did he start to change his story or something, or not testify consistently?
As far as I know, no, he was going to testify consistently as to what his police report was.
So what is the issue with him saying if he doesn't testify according to his statement?
No, the statement that Mr. Ringstrom made was if you testify for the defense.
Okay, so how does that make him a necessary witness? Is he going to testify?
I don't know, Your Honor, if he is or isn't.
How do you not know if a witness is going to testify in a case that you're set for trial in less than 2 weeks? How do you not know? You should have talked to him.
Oh, I spoke to him.
Okay.
Like ultimately, I don't know what he is going to do at trial. I don't know if he's going to plead the fifth, which he
Well, he
decided.
can't. Did I grant him immunity?
No, he was not granted immunity, Your Honor.
Oh,
And this
okay.
was dealing with the file of the 3614. It's not even this file 3619.
And I'll get to
What had happened is, if the court wants me. to
Yeah,
do
go for it.
What happened was we had.
By the way, this happens a lot. I know defense attorneys do it. They always do it when they've been practicing for about 4 or 5 years or somewhere less than that. They always throw the attorney on the prosecutor and almost never, ever does it ever happen. Go ahead and explain it to me.
So we had 4 witnesses that we were prepared to go call in at the prelim. 2 of them needed use immunity to be able to testify. After the 3rd witness, in 2.5 hours of a preliminary exam, prosecution decided not to call the other witness that we were going to give use immunity to.
Okay, who is that witness? Just give me a
It was
first
Mr.
name.
Olam at the time. So then Mr. Dick decided he wanted to call Mr. Olam as his witness.
At the prelim.
At the prelim.
Okay.
And there was some discussion. I don't remember the specific words, obviously, with the transcript or whatever, but there was some discussion as far as me saying that if he's testifying for the defense, he's not got our use immunity because we were the ones who were using it at that time.
All right.
And then after more discussion, I just agreed I would call him as a witness, but the court at that point in time had indicated that they just wanted to go forward.
All right.
I have no
Mr.
idea.
Dick, what's your version of that? Because that's a little bit different than what I heard. So tell me what happened.
So at this hearing, yes, there were 2 deputies and another witness who had been granted immunity had testified. And Mr. Ringstrom declined to call the other witness based on my prior discussion. We thought there might be.
You said he decided not to?
Pardon?
You said Mr. Ringstrom decided not to call that witness, Mr.
Yes,
Owen?
sir.
All right, copy.
And I ended up calling him.
Okay.
And Mr. Ringstrom kind of blew up initially about that and said that if you testify for the defense, I'm revoking your immunity. And part of not having the transcript today is we're relying on this as the offer of proof. And it may be better to address everything with that. But I did speak with this witness, and I do not ultimately know if he's going to testify or plead the fifth or what he's going to do here. So at the
You got to spit it out, man.
Sorry, at the same time, we were.
You may as well say every other word. You're not doing but
Seriously.
I cannot follow when you're talking. So just keep going. Let's see what you get.
At the time of the preliminary exam, there was.
This is insane. I can't
Again,
follow it
I'm
either.
saying I believe, Your Honor, because I do not have the record or the transcript of the record. There.
All right, so let's,
Yes.
There was a signed order for use immunity that was in the file. And it dealt with Mr. Owen. That order says, is in response to a motion for immunity or an application for use immunity. By the way, there we go. It's in the file, but it's not even signed by the judge.
It's
Right.
because he did not testify, so therefore the judge did not sign it. The judge was going to have him come up if I were to call him to sign the use of it.
Yeah. So hold on. It may have caught the prosecution off guard, but he didn't have immunity. And then what you run the risk of doing is pulling a witness on the stand that you might know is going to invoke the Fifth Amendment right. And you would have to then get immunity. So if he chose not to call the witness and the judge didn't give immunity, and if he's telling the witness, hey, by the way, I didn't call you, which means you don't get immunity yet. All he did was the right thing by telling the attorney, I'm sorry, the defendant, or I'm sorry, not the defendant, the witness, hey, you don't have immunity. Be careful of what you say. He did the right thing. Now, if he testifies and you all want to get him immunity, fine. But how is that even relevant? Let's do it that way. How is what he said to Mr. Olam relevant? Because you don't know if he's going to test. Are you going to call him, right?
That's the intent.
Okay, Mr. Rickstrom, are you going to call him?
I would probably want to call him if there was a trial, yes.
All right, so you're going to want an order of immunity.
I would give him the use of immunity, yes.
Okay. And then what would, so he's going to put the witness on the stand. The witness is going to say A, B, and C. Then you're going to get up and you're going to either challenge him and say, well, that's not what you told the other people or whatever. That's fine. That's prior inconsistent statements. Got that. Then you're going to challenge him to say, what? His credibility because of what he said to him?
No.
All right. How would you use this? How is it relevant under 401? How is it relevant to make a element of defense more or less probable?
Well, it would make it more or less probable that Mr. Olam was threatened or felt threatened by the statement.
How do you know if he felt threatened?
Right.
What does that matter? How does that go against his credibility?
Exactly.
It weighs against his
That nails it
credibility
right there.
because it actually has an influence now of how he is testifying or if he chooses not to testify.
If I give him an order of immunity, he can't choose not to.
Understood.
So there goes that one. So then the question is does he testify consistent with what he had to say before? John, did he testify at the prelim at all?
No.
No?
He did
All
not
right.
testify.
So, all right. How is the prosecutor a necessary witness?
Well,
he's not. You were there.
Yes.
There you go. Maybe you need to be the necessary witness. Or Ms. White, but she has the right to remain silent, or the court reporter, or the judge before whom it was taking place. So the answer is you don't need Mr. Ringstrom. You have a transcript. We'll have a transcript by that date. You will strike Mr. By the way, why was Mr. Ringstrom on the other file then?
There, again, I'm saying this because I don't have the transcript, but I believe that one of the key witnesses in his other case, their mother was sitting in the courtroom here when that was said.
Okay.
And because I construed what he said as a threat rather than a warning, I believe that they would perhaps as well.
Know, did you talk to her?
No.
No, you don't even have the facts for the motion. He's not a necessary witness. You haven't talked to her. Boom, there goes that one. You don't know what she's going to say. You don't need the preliminary exam transcript to figure this out. This is very, very simple. we will get the transcript. I'm going to expedite it and I'll get it to you by the middle of next week. And if I have to work with a court reporter or a different court reporter to get it done, we'll get it done. Now, as for that, you're also going to set the other part for a hearing. And you're going to explain to me a lot better than anybody has done today as to how it's relevant to have a test of DNA of pee into a bottle. Sounds like at best you're going to say that, one, the person lied and didn't know how it should have tested positive, or two, that she peed into that cup before the time and date which she says she received the methamphetamine from, allegedly, Miss White. Now, did that same person get tested again after that person pointed the finger to Miss White? That's important to know.
I'm trying to understand, Your Honor, basically what it is that person wound up giving to Miss White the pee.
Yep, I got it.
That tested positive.
Yep.
Molly White had accused her of giving her dirty pee. She said, I couldn't give you dirty pee. And then that person, then after that, I believe was given the meth.
So, right, I got it. So then did she get tested after?
She got tested after her saying that Molly White had given her the meth.
Okay, and then she tested positive with
She
blood
tested
draw.
positive for
Okay, so we don't have any report that said, right, that urine was not tested at a lab.
No, that urine was not tested at a lab. That urine was tested through the gym.
Got it. So now what you're requesting is something else. What do you think you're requesting now?
Well,
if I were, well, I hate to say this is tough because these motions are kind of tough because I end up telling you all what I think you're missing. And I tell you what I would do. Now that's the problem. But here's what I would hold your feet to the fire on. What are the nanogram levels? That's what you want tested. The DNA is not necessarily the information you're looking for. That might be to help tie it to the person who says, yes, that was my pee. But you're looking at nanogram levels. Because if the nanogram level in that blood, and if that blood was done a week later or 2 weeks later from the whole pee fiasco, there goes that argument. So you all put this together a lot better than you did today. We'll deal with that then. As of right now, the case it remains on the trial docket.
This is straight insane.
All right. And so far, I'm going to strike Mr. Ringstrom as a witness, but he is not a necessary witness. If, for instance, let's say Mr. Ringstrom had talked to a witness, Mr. Ringstrom, if he was the only one present, now he's a necessary witness. If he does it with a law enforcement officer, he's no longer necessary. You can call the law enforcement officer. So here you had a room of people. He's not a necessary witness. If she feels intimidated, that's a question you can ask her. Did you feel intimidated? But then he's going to put out a transcript of whatever was said or a recording and play the recording. And then the jury's going to make a determination if that was reasonably to feel intimidated. I'm going to tell you often, you end up putting the word intimidated in people's mouths. But because I deal with that a lot when I deal with personal protection orders. I was harassed. Well, what do you mean by harassed? And they tell me, I'm like, well, that's not the definition of harassment in the law. Anyways, you guys can set this for a motion. I'm going to go find somebody to put this thing in the transcript request line ASAP. All right. So we have nothing resolved today. This case, 3619 goes to trial unless we make a change next week. I'm getting tired of adjourning trials. So, all right. Very much.
Your Honor, this trial was set for 2 days based off of the preliminary exam, the length of the preliminary exam and the witnesses. I think that we probably are going to need 3 days.
have in this case?
Thanks, Your Honor. Balance including court costs is $4,018.68, and I talked with Miss
That was absolutely insane. I haven't seen this one yet either, but it may be related.
Aguilera before the hearing, and she is planning on turning in her keys on Monday.
Okay.
And so I told her we would just adjourn to the 29th, and as long as she turns in her keys, and if you turn them into the Dropbox, make sure they have your name on them, but we'll dismiss.
Okay. Is that all correct?
Yes.
Okay. So I'll adjourn this out then to August 29, 2025 at 3 p.m. I'm glad I made her bring up the baby because see what would have happened is she would have moved out. She wouldn't have come back. I never would have got this baby employed.
Thank you.
All right. You take care. Who's that with you?
Oh, my mom.
So that's grandma? Yeah, I knew that. And the reason I knew that is because when she handed you the baby, you grabbed that baby like a grandma would grab it. You guys take care.
Okay, this was sent to me by Ruggiera's emote module. All right. The description is so weird. I'm not going to say it because I don't want to give away what it might be. The description is so weird. I have no idea what's going to happen.
Court does call the case of Evergreen versus Keontae Lowry.
Jillian Egan for plaintiff.
Hello.
Hi.
Your name?
Keontae Lowry.
All right. What's the claim on this case?
I have a balance including court costs of $3,250.74.
All right. Ma'am, how are you intending on getting that paid?
I did speak with Hawk. They sadly told me that they won't be able to help me till September, which that's too far out. And then
Pardon? Say again?
Hawk
Yeah.
told me they won't be able to help me until closer towards the end of September. I'm not sure why, but that's literally what they told me. And then I also applied for a SCR. I have not gotten a decision or anything on that yet. I did get told by Sydney, which is the account manager with Evergreen. She told me that as long as I bring my balance down to 3,000, that the SCR would be able to assist me, is what she was told. I'm not sure how or when she was told that, but I do plan on making a payment every 2 weeks because that's when I get paid, every 2 weeks.
They probably have that wrong. Hawk would be able to assist you if you get your balance down.
Okay.
And how many people are in your house?
Just myself.
All right. So even if you get an SCR, the maximum they're going to pay is 410.
Okay.
Okay, so you're still kind of behind the 8 ball. When do you next get paid?
I get paid. Sometimes I get paid early because of the bank I have, so it'll be either next Wednesday or Friday.
Okay. All right. And how much will you be paid?
I'm not sure because my job did cut my hours due to me going back to school in September. I don't know why they cut my hours so early, but however much I get paid, depending on what else I have to pay for, I'll just put whatever I have towards.
Ballpark it for me. About how much?
Maybe about 500, I'll say.
I'll just put down, that's an estimate, 500.
Okay.
And then you can do that by the 22nd. But you need to get back in contact with Hawk because if you pay the 500, that's going to bring you down below the 3,000. But I don't know what funding's available.
Right.
Okay.
Okay.
So I'll give you a shot. I'll adjourn it out to August 29th.
Okay. Thank
2025 at 3 p.m.
Okay. Thank you.
Your Honor, as far as I know, I have a note from my client that Hawk is probably not going to have additional funding until late September or October. It's all
That's why she went into the September.
Yes.
Okay. We'll figure something.
Okay.
All right.
Thank you.
Evergreen versus Sin Parker. Sin Parker and Anastasia Parker. Neither party are here. If you'd like to take a default, raise your right hand. You solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God.
I do. Thank you, Your Honor. This is a case for termination of tenancy. A notice to vacate was provided for the lease end date of July 20th, 2025. And so this case was filed on July 21st. Possession has not yet been returned to my client. So at this time, we're asking for default judgment for possession only with the writ to issue after 10 days.
Judgment to the plaintiff, that's by default for possession. No redemption amount, writ issued in 10 days. Glencoe Hills versus Yaritza Herrera.
Hanging for plaintiff.
Hello.
Hi,
What's your name?
Yarisa Herrera.
All right. And how much do we have owing now?
I have a balance including court costs of $1,596.36. I have a note that as of the 13th, the Ann Arbor Housing Commission hadn't processed the income update, which was provided before the 1st.
Got it. So there's going to be an adjustment.
I hope so.
Okay. Well, she paid, and you paid something, right?
Yes,
From-
I've been paying my portions. It looks like earlier this month or this week, I got an email from Ann Arbor Housing that they don't have my loss of income yet still reported towards my voucher. So they're still calculating that.
How much is your
They're
monthly
still
portion?
just
About
telling
four?
me to pay between
Pardon?
530, and I've been paying around that up to 600.
Oh.
I really don't even know what my
So
amount
we're
is.
waiting on basically a research issue. So we can look at that. What I'll do, let me adjourn you out 2 weeks. Let's hope they get that calculation and see what it does to this number. August 29, 2025, 3 p.m.
Okay.
Okay?
Thank you.
Thank you. Court does call the case of Gulfside Lake versus Dion Brown.
Jeff?
How you doing? Very good. How you?
Okay, I'm really confused now because none of this is tracking with the description I have, but there's more to go.
You doing? All right. All right. What are we doing?
Sorry, Your Honor, what case is this?
Dion Brown.
Okay, thank you. I have a balance including court costs of $294.01.
294.
Yes, sir.
1 cent. Okay, we coming down quite a bit because you paid the 600.
And then I paid 200, I think, yesterday or day before yesterday.
That's included in your figure?
Yes.
Okay. Well, if he paid 800, he should have be about 244, but then if you add, I got it. Okay, and he had $50. That's how we got this.
Okay. It's all late fees, I think.
So when can you get this paid?
I assume we're here for some reason.
I can pay it on the 20th. So
On the 20th? All right, so here's what I'll do, Mr. Brown. I'll adjourn your case out to the 29th, 2025 at 3 p.m. If you get that paid on the 20th, right, they'll dismiss if you got everything paid.
Good Lord.
All right.
Fair enough?
Fair enough.
Okay.
All right.
Now it's coming together. Brackens appears to have gone to the throne here.
Thank you. Have a good week.
Court calls case of Gulfside Lakes versus Sarah Brown.
Good afternoon, Your Honor. I'm here.
Okay, Sarah Brown and Jalen. Hello, Miss Brown.
Yeah,
I need you to turn on the
Hello.
camera.
Okay. Oh. Okay. I'm here, Your Honor.
Okay. Yes, ma'am. All right. How much does she have? How much does she owe?
I have a balance including court costs of $1,541.88.
Okay. And she made that 600 and 1,000. It looks like she did exactly what she said she was going to do.
Yeah,
So-
I paid $2,000 yesterday, so I could pay the balance on the 20.
Hold on a second. You paid 2,000 yesterday?
Yes, sir. And that should leave me with a balance of 1541 and some change.
Yes, that's what I.
Okay, so she did it different than she told me she was doing it, but she
I
got,
paid
oh,
it.
I got you.
Yeah, I paid a little
I got,
more.
yeah, I got you. I got you. Okay. So when do you think you can get this paid off?
By the 29th.
By the 29th?
Yes, Your Honor.
Okay. I'm going to believe you. So I'm going to adjourn this out August 29th, 2025, 3 p.m. Okay?
All right,
And
thank you
so
so much.
not a problem. If you get it paid before that time and they have it, they may just dismiss the case. Okay, Miss Brown?
Okay, no problem. Thank you again.
All right. You take care. Have a good weekend.
You
Gulfside Lakes versus Bonnie Jacques and Brandon Jacques.
Jillian Egan for plaintiff.
Okay, yes, Mr. Jacques is here. Okay, where are we on his case?
I have a balance including court costs of $4,245.05.
$4,245. It's okay. Sir, I thought we were gonna have the balance paid.
Yes, I was supposed to
I
pay
don't
it
know.
today. The funds have not hit my account yet to make the payment. So
Okay,
I'm asking that if I could have next week to get this resolved. I can pay it in full.
okay. Here's what I'll do. I will find no tribal issue after hearing. I'm gonna grant a judgment for possession for that total amount that's due, right? And you think you'll have it next week, you said?
Yeah, I should have had it today. I don't know why it hasn't cleared my account. So if I could just have next week to resolve it, I would appreciate it.
Okay. Well, what I'll do is I'll just have the standard writ date of the 25th, and that should give you plenty enough time to get it paid.
I appreciate
Okay?
it. Thank you, sir.
Not a problem. You take care.
You too. Bye-bye.
Bye-bye. Gulfside Lakes versus Erica Hall.
Jillian Egan for.
Tried to sit over on that other side, trying to like hide. Well, how are you doing?
Okay.
All right, where are we on this case?
I have a balance including court costs of $2,846.63.
Okay. So we've come down about 1,000.
I paid 1,200.
When? Do you know?
The first.
Kind of looks like the Intimidator. Maybe they were
Was it
involved in the same bleach
first, you
accident.
said?
Your Honor, I see a payment of $1,200.
On the first, and that's already,
I did it on the 4th.
Oh,
okay. And so that's already been taken off of this number.
That's correct.
Okay, got it. That's where I see my, okay, got it. Okay. How you gonna get the rest of this paid here?
I can get it paid by the first. I spoke with her.
The first?
Yeah.
All right, let's do this then. Let's lock in the figure. I'll find no tribal issue. Grant a judgment for possession with that total amount of 2846. Yes, 4663. And what I'm gonna do is do it this way. I'll make it payable by the 31st. That's actually okay.
I can do the 2nd.
You can do the 2nd of September? Okay. September 2nd, 2025. She just did that to try to be nicer than me. No, okay. Yeah, all right.
So.
Okay, we'll get that paid, get it paid by the 2nd, you're all set.
All right, thank you.
Take care. Court calls case of Gulfside Lakes versus Emmett Redwine.
Jillian Egan for plaintiff.
Oh, boy. Oh, boy, here we go.
Well, yeah,
I'm doing great. How you doing?
terrible.
Oh, boy.
Yeah, you wanna know why?
Yes, sir.
Spider bit me in the head and it made me lose my hair, and I got some bald spots in my head. Now I'm all messed up.
Hold up a moment. Your hair has been like that since.
No.
But yes, it was.
But see, I didn't know what the problem. I had a little bald spot in my head.
Right.
Like, okay, maybe I'm losing. I gotta figure out something. And I went to the doctor, found out a spider bit me in my head, and let me cover spots. So now I got an appointment. I wasn't trying to come here, so I want to go video. So you have to see me like this.
Spider.
Okay. But we found out what it is.
Yeah, I did. I found out what it is.
And that's good news.
Yeah.
Did you get superpowers?
All right. Where are we on this?
The balance including court costs of $4,491.78.
All right.
I paid $1,500 today.
Today.
Yes.
Okay, so you paid $1,500 today. And then when are you gonna get the rest of that paid?
I could pay minimum another $1,500 in 2 weeks, for sure.
Okay, by the 29th?
Yeah.
Okay, that'll take 3 off of that, and then you got $1,500 that you gotta get paid when it's gonna be 2 weeks after that. Is that what? How much is your monthly rent?
$1,219, something like that.
Okay.
Did Brackens drop a deuce while I was distracted?
So here's what I'm gonna do for you, Mr. Redwine, because Lord knows I don't know how you do it, but you always come through. So I'm gonna find no tribal issue after a hearing. I'm gonna grant a judgment for possession for the total amount of $4491.78. Okay. You've already paid $1,500, and you're to pay $1,500 by the 29th. If paid, so let me just say this. Writ date is the 29th of August. You're to pay $1,500 on the 29th. If you pay that $1,500 on the 29th, then the writ date would be extended to, you'd have to have that full amount paid by September 12th.
I can't even see. Oh, yeah, for sure.
Okay?
Yes.
And then so I'm doing it this way, but I'm not including your September grant.
Yeah, I understand.
So this will give you a chance to just clear this balance and still owe your September rent.
Yes.
Got it?
Yes, sir.
All right. Good. Okay, you take care of yourself.
Yeah.
All right? Your head doesn't look too bad this time. No, it doesn't look too bad. I'll let you wear the hat. No, you all right? Ellen, you shouldn't have called him out like that. Court calls the case. Call Side Lakes versus Garrison Brackens.
Jillian Aiken for plaintiff.
Well, here he is.
I'm right here. Oh, yeah. Okay, Mr. Brackens is there. Okay. Where are we on this case?
I have the balance including court costs of $3,558.99.
Give me that number again. I'm sorry.
Yeah, $3,558.99.
All right. Did you pay the $1,000?
No, sir. After court, I was having a conversation with Melissa Dot. She's like the landlord. And I was just asking her if there was a way that instead of me just paying, if I could just move out in the 30 days, like the eviction. And then on the 4th, I was sent a demand for possession letter, and it was basically saying I had 2 options to either pay the rent owed or vacate the premises within 30 days. So I was just going to do the vacate the premises in 30 days option.
I got all of it at the end.
That was on the 4th?
Yes, sir.
Your Honor, my client sends out monthly demands for possession, and I think there is language on it that says that it doesn't affect any pending case. Mr. Brackens, when were you planning on moving out?
On the September 1st.
Okay. Your Honor, if you would do a judge, if you would.
Got it.
do a Judgment for the 29th.
Okay. It won't
Yeah, you
happen
want that
before then
judgment.
anyway. Gotcha. So what I'm gonna do is I'm gonna grant a judgment for possession, finding no tribal issue for the 355899 with a writ to issue August 29th. Okay? And if you move out, then you'll be all set. They're only looking for possession of the
Thank you,
premises.
Dilly Dave.
All right, thank you, sir.
All right, thank you. I don't know what Alan's doing. He's just like sitting there.
Record in the matter of Highland Flats versus Honeycutt 5-03444 LP. Council, can I have your appearance, please?
Good afternoon, Your Honor. Attorney Hamza Sob on behalf of the plaintiff.
And I see Harley Honeycutt and Angelica Brito. If you can unmute and state your name for the record. Angelica Brito.
My name's Harley Honeycutt.
Okay, this was a motion to set aside dismissal
I believe this is Lab Matt's fault.
and reinstate case. It says plaintiff filed a complaint on June 18, 2025 for the property in question. There was a hearing back on July 23rd for non-payment of rent before this court. The hearing was scheduled at 3:30. Counsel for the plaintiff did zoom in for the hearing on the correct date and did check in with the court. However, after waiting in the waiting room in courtroom, counsel for the plaintiff got disconnected from the virtual court hearing after 20 minutes of trying. Counsel and plaintiff was unable to reconnect, but was advised by the court clerk that the case was dismissed without prejudice. Plaintiff's knowledge, to plaintiff's knowledge, the defendant remains in the home to this day and currently owes $2,597 in unpaid rent. Did I miss anything of importance in your motion? And
No, Your Honor. I think that's perfect.
help me understand why you would be in my Zoom room for a hearing.
I believe it was a Zoom hearing or a mistake of a Zoom hearing.
I don't hold hearings via Zoom for landlord-tenant. You had to, that's in person only. I say that like a broken record at the pre-trial.
I understand that, Your Honor. I'm always in the 54A. I believe one of my colleagues had a scheduling conflict and he appeared via Zoom. And then he was the one that got disconnected. Sorry?
Oh, no, absolutely not. Mr. Asphalt, who was here, and then you just refreshed my recollection. I know why the case was dismissed. Mr. Asphalt was here. Mr. Asphalt handled the hearing and then he left. Mr. Asphalt got into a vehicle and started driving and tried to log in and pretend like he couldn't hear the court because he was driving while into the court. And this is after I've already had the same issue with Mr. Asphalt by driving and trying to operate Zoom, which is against the law. And he lied then. And so this time he got disconnected. He did not have a good signal because he's moving in a motor vehicle during the time. So the case was dismissed. He had no authority from the court to appear via Zoom for said hearing because all my hearings are in person. He also had already had an issue with this court about appearing while driving a vehicle. I do not let anyone, especially litigants, appear while they're driving a car. And I'd expect an attorney who has a bar license to know better. So the case was dismissed because he failed to appear for court. So he can reissue the case and start from scratch. Maybe he'll learn how to follow the law in the courtroom.
I understand. Thank you, Your Honor.
Thank you. You're all set.
Yeah, you want to get out of there. You definitely want to get out of there. All right, let's see if we can do this thing.
After we'll take this. We're not under as much of an acute time.
It's from Lady Knoll.
Because The parties are all here live.
Lady Noel, tell me in the comments. I'm curious. Is Noel because you're a Seminole? Is this an FSU reference? I'm just curious.
So we'll finish this matter and then we can place your resolution on the record. Now, I would tell everybody that comes to Centerville, they could go to Yoder's for lunch. So that's just down the street. Well, it's probably very crowded today.
There we go. Lady Noel.
All right, we're back.
Is a cinnamon roll, as I suspected.
Matter that was put in on short notice, but we're going to resolve, I think, our next two cases.
My staff.
All right. I didn't have time to clean up the dud spaces. This came to me midstream here. Yeah, that cock talk with Mike picture comes via Zach, and I am impressed. I don't know how they did it. I can assure you I never streamed while holding my cock.
1:30.
So this is some AI stuff, but it's good. Those are my hands. All right. I thought the
Use my thumbs all the time.
Type with one finger. Young people type with two thumbs or two fingers.
I guess I'm old then.
Well, you're using both fingers, so.
Well, I already have like carpal tunnel hands, so like it seriously hurts to use my thumbs all the time. I know it sounds ridiculous, but it's true.
Well, now the new kids, like, we have an imprint now. That's how you know you're constantly on your phone. You have this new indent.
It'll be the generation. I'll dig you guys up.
There's us.
Is there any place to write for me one sign to do that on the right?
I can just do it.
Your Honor, can I address the court before we go on the record?
We're on the record. I can shut it off.
I know the court indicated that it was going to be live
It
streamed.
is. We're on the live stream right now.
I told my client that you're going to be live streaming it. I would object to the live stream. This is going to be under 769.4A. In that statute, it indicates that these hearings are public on the public record. I get that. But public record doesn't necessarily mean that it's live streamed to the world. And so I would object to the live streaming
you
of
get the
it
bonus
while we're
package.
having this sensitive
You're on Law
plea
Talk with Mike.
where the file will be closed after this to the public. So I would make that objection.
All right, your objection is noted. It's overruled. This is a matter of public interest. It is a public charge. She's not yet been placed on deferral status, and we're in our courtroom and
Tough
I'll go on the
nuggies.
record.
Thank you.
All right, this is a special assignment case from Kalamazoo County. The parties here are the state of Michigan, in this case, the county of Kalamazoo. The matter was assigned as special prosecution to the St. Joseph County Prosecuting Attorney's Office, and Gary Gabry is handling the case for that assignment. In light of that assignment, the Supreme Court assigned the matter to the St. Joseph County District Court, namely me. And the matter was charged. This is Kalamazoo County file number 2501371FY. People versus Tammy Rayshon Key. That's you?
Right, yes.
Say that again?
Right.
Oh, right. I can't read my own writing. It is Ray, not a Key. Ray. I met you briefly on screen last week at the pre-exam conference. The charges here are alleged to be 2 counts of resisting and obstructing a police officer, Officer Grace Meisner of the Kalamazoo City Police Department, and Kayla Miller, also of that department. Those are felonies punishable by up to 2 years imprisonment and a fine of up to $2,000. Because they were felonies, the matter had to be set for a preliminary examination. We had a pre-exam conference. Both attorneys advised we were just going to set this for a prelim. So we worked out the logistics of me coming to Kalamazoo to hear this case. A few days later, we got a series of emails indicating that there'd been some resolution and they wanted to do it as soon as possible. I will be gone next week or much of next week for the Judicial District Court Judges Conference. So we crammed this in this morning at 11:30, and I appreciate everybody's indulgement. Met with Attorney Michael Hills, who's representing the defendant, and Prosecutor Gabry. They advised me in chambers that the prosecution intends to dismiss both counts of resisting and obstructing a police officer, the felony charges, and 1 count of domestic violence. The defendant would enter a plea to 1 count of domestic violence. As I understand it, it's a slap. And the other count would be dismissed. Prosecutors recommending that I put you on a domestic violence deferral probation. Mr. Hills indicated at that point that becomes non-public. The probation would be, I'm presuming, through Kalamazoo County, unless they disqualify also. They may have an apprehension about having their probation department handle this case the same way that the court. So that may be reason enough to set this for sentence. At any rate, Ms. Ray, the felony charges would be dismissed, and it's envisioned that you would enter a plea to 1 count of domestic violence against Adrian W. Lindsay, and the other charges would all be dismissed. I cannot put you on a deferral program unless the prosecutor consents. Mr. Gabry, have I stated the plea agreement correctly?
You have, Your Honor, and the record should also reflect that I did talk to Mr. Lindsay, explained what my proposal was, explained what, likelihood of period of probation and the kind of counseling that would come forward with that. And he was in agreement and does not object to placement under the statute.
All right, thank you. All right, Ms. Ray, do you understand that if you plead to this charge, you'll be giving up your right to have a trial in front of a judge or jury? There will be no trial. Do you understand that?
Yes.
If you had a trial, you'd have the right to be represented by an attorney. You've retained Mr. Hills, and that's certainly fine with us. You could have also asked to have had an attorney appointed, either under the Kalamazoo system or ours. At any rate, that matter's been resolved with you retained counsel. If you had a trial, you'd have the right to take the witness stand and testify on your own behalf. Tell your side of the story. You also have a right not to testify, and if you did not wish to testify, the judge or jury could not hold your silence against you. You'd have a right to have any of the witnesses, including Mr. Lindsay and the officers, for or against you, subpoenaed to come to court so they could be questioned under oath, and you would continue with your right of presumption of innocence unless the state was able to prove your guilt beyond a reasonable doubt. You understand?
Yes.
Anybody threaten you to get you to plead to this charge
No.
or promise you anything?
No.
All right. This happened in the city of Kalamazoo. Were you and Mr. Lindsay at one time in a relationship
Yes.
and you share a child?
Yes.
How old is that child?
11 months.
All right. This is alleged to have occurred on May 23rd of 2025. On that date, were you and Mr. Lindsay in contact with each other regarding exchange of custody of the child?
Yes.
Did you and he get into an argument about a car seat or the facts of the exchange of custody?
Yes.
And did you lose your temper and slap him in the face?
Yes.
And Mr. Gabriel, are you satisfied with the factual basis?
I am, Your Honor.
Mr. Hills?
Yes, Your Honor.
All right. Ms. Ray, the reason I'm here is because I don't know you. I know of you. Mr. Hills tells me, and I don't have any reason to disbelieve this, you've got quite an accomplished resume. You're involved in lots of things in Kalamazoo. I also don't know Mr. Lindsay. What I also don't know is exactly what the policies and procedures are of the Kalamazoo County District Court and Probation Department. I have here at my availability of probation. We have a specific probation for women. It has a women's anger management program that I actually started when I was county prosecutor, and a supervision by our probation department and a set of costs and how everything works. This kind of caught me, but not.
Oh, that's cute. They have a different thing for men. It's called jail.
Exactly by surprise, but I was surprised by your lawyer a few days ago that this was going to be a plea. I didn't know the terms of the plea agreement till just this morning. I didn't really have time to work out the logistics of how they want me to do this in Kalamazoo County. There's also the issue about whether Kalamazoo County Probation Department is going to be recused also. We work with them regularly. My probation officers know their probation officers. I've met some of them at conferences. We're border counties. Often we have people that manage to get in trouble in more than one place. So they're a competent professional office, but I'm not sure what they want. So the upshot of all this is we have already cleared the date of Tuesday, August 26th in Kalamazoo County. I'm not sure which courtroom it is, but we had reserved that space for the preliminary examination. That will be more than 10 days from today. The domestic violence statute envisions that when there's victim input, there would be at least a 10-day delay. I think Mr. Lindsay has given Mr. Gabriel the blessing to go ahead and do the sentence today. He's written a letter, and he has strong feelings about this. The other problem, and this happens all the time, you guys are stuck with each other for the next 17 years. You're going to be parents of this child, and you're going to need to co-parent, and you're going to need to learn to get along with each other. let me just confirm from you, you've never been previously convicted of any assaultive offense?
No.
All right, because you're only eligible for this deferral one time. And I believe that you were not, but I needed to confirm it for the record. So we're going to do the sentence in this matter at 1:30 on the 26th of August in Kalamazoo. I don't have the whole police report. The letter Mr. Gabriel gave me is quite helpful as to input from Mr. Lindsay.
Yeah.
He has a right to be present. if
Don't
he
mess with
wishes
my
to
chat.
be.
That's what I'm telling you, people.
And at that point, it's envisioned that the matter would be deferred. Now, let's talk about that. Domestic violence, I didn't even state this, as it's charged as a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. It would also prohibit you from owning or possessing a firearm for at least 8 years. Now, that's important if you're in the military or you're a police officer. Here in our county, you have lots of people that hunt, target shoot, and it's important to them to preserve their
Commit crime.
rights to use or possess a gun. If you're placed on this probation and you successfully complete it, the charge is removed as a public record of conviction. Now they keep a private record, the state police do, because you're only eligible for it once, so they have to keep track of it, whether there was one or not previously. But what I expect is that you're going to comply with the terms of this probation and successfully complete it. But
I don't.
I need more information before I can make that decision. So I have accepted your plea. Both counsel are satisfied with the factual basis.
Your Honor, may I?
Yes.
You left a cliffhanger.
What?
The cliffhanger is if you complete it, then you can.
Oh,
possess
well,
your
okay.
guns.
Here's the cliffhanger. I said I envision you'll come, if you don't complete it and the wheels fall off, you're subject to a jail sentence and the matter would become public and you'd lose your rights. So it will, our probation
Hate for this to
includes
get
terms
out.
like no drugs or alcohol. I don't believe drugs or alcohol are a factor in this situation, but everybody that's placed on probation has that condition. It would also include a condition of no assault or threatening behavior. It would include a condition that you complete a certified domestic violence treatment program. And I'm not exactly sure what their program is in Kalamazoo County. I told you I know what ours are. And there's, I think, currently a no contact provision in place. I'd like to address that there isn't.
No, the no contact provision was not in effect. We had that issue.
I get it. We discussed that at the pre-exam.
Yeah, so there's a no assaultive behavior situation so that they can, exchange custody.
You have just this one child together?
Yes.
Okay. And does he also reside in Kalamazoo?
Yes.
So you're close proximity to one another.
Yes.
Does the child have a primary residence or do you share custody of the child?
I would say my residence is the primary residence. We do share custody. However, his parenting time is pretty low.
All right. So the child mostly resides with you and then he has parenting time.
Yes.
All right. Again, that's stuff I didn't know and I would want to know at the time of the sentence. So we will revisit this. I don't yet know exactly which courtroom. Let me see if it's on that notice. That's the notice for today. Well, we will make sure everybody is aware of where we're supposed to be. In the meantime, I'm going to have my probation department contact their probation department and make sure that I am apprised of their procedure for domestic violence deferral sentence. Mr. Gabriel, anything further we need to place on the record?
Your Honor, I would like the record to reflect that the letter that the court referenced from Mr. Lindsay has also been provided to Mr. Hills prior to what's going on the record. So he's had an opportunity to review that. I'd also like to indicate for the record that this case was in fact charged initially as a felony under the probable cause standard. However, once I was assigned, I reviewed video footage, had discussions with Mr. Hills, and email correspondence been had with the police department. And since there was no aggressive or violent behavior demonstrated towards the officers, and this was a highly emotional situation, we saw no reason to proceed with felonies. And by her accepting responsibility to the domestic, we certainly understand, and that's why we've made the referral or the recommendation for the deferral program. Thank you, Ron.
Thank you. Mr. Hills, any further?
We appreciate the discussions with the prosecutor. That is all accurate, as well as I do have a copy of the letter from Mr. Lindsay.
All right, you provided me with a Kalamazoo County form, criminal pretrial statement, and indicating pled guilty to DV first with treatment as first offense DV, dismiss remainder of file. All right, very good. I'll see you all in Kalamazoo on Tuesday the 26th at 1:30.
Thank you for taking this up.
Thank you.
All right, thank you.
Good afternoon, Mr. Was it Truman? Thurman, excuse me, ma'am. You were arrested for burglary with an assault or battery. I will appoint the public defender's office for you. There's probable cause for the charge. Ma'am, you are ordered to stay away from your mother, the alleged victim, Denise Michelle Manns. No contact with the alleged victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. And no contact with the victim through social media or other electronic means. You must stay at least 500 feet away from the victim, her home, school, and place of employment at all times. Do not engage in any criminal activity. Do not use or possess illegal drugs. And do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. Do you understand the stay away order, ma'am?
Yes, ma'am.
All right. There's probable cause for the charge because it's considered a first-degree felony. I have to grant the state's motion for pretrial detention.
I would ask that you not find probable cause, Judge. There's
No.
nothing indicating in the arrest form that her mother has legal custody to Miss Thurman's child.
Even if there's nothing here mentioning it, she should go with the police. She's not allowed to enter the home. She forcibly opened the door and she's pushing her way inside and pushed the victim, and then they're fighting. So there's probable cause for the charge.
It's
She
not
should-
intent to commit a crime. It's intent to get her child who her mother does not have legal custody for.
And how do you know that? She's 21 and homeless. She showed up at mom's house with a man, and mom said, you're not getting a child.
But if mom doesn't have legal custody, mom doesn't have the authority to make that decision over Miss Thurman's child.
How do you know she doesn't have legal custody?
There's a physical fight inside of the house.
There's
It
enough for
doesn't
probable
indicate
cause.
that Miss Manns had any legal authority to have her child. And doesn't
Okay.
indicate that Miss Thurman doesn't have legal rights to her own biological child.
Then you call the police and they would make arrangements for her to get her
Unlawfully enter
child.
somebody's house and beat them
That's
up.
not an intent to commit a crime there is. Intent to get her child, Judge, who's being unlawfully held.
That's intent to commit a crime to obtain something inside that she wants. So there's probable
No,
cause.
Judge, she has a legal right to her child. There's nothing indicating she doesn't have a legal right to her child.
Okay. I'm granting the state's motion for pretrial
That's
detention. I
That's
think you should,
over-defense objection, Judge. There's
I-
nothing indicating who has a legal right to have that child in the arrest form. I'd ask
Oh.
for a probable cause hearing.
She told her to leave, and the defendant proceeded to physically
So,
fight. The
just so
Doesn't
you-
give somebody the legal right to hold your child when they don't have the lawful authority to do so.
okay, so can I just say one thing? Since I sat in family court for many years, maybe we'll go back soon. You have to go file for, what's it called? A pickup order to get your child. So you go and file a motion to get your child returned, and a judge signs an order to give you your child so you can pick up your child. And excuse me if it's the wrong terminology, but when that situation happens in the domestic area, you have to go to family court and file paperwork with the court. And if she has rightful custody of the child and the mother does not, they'll give her a order to pick up her child, or she can use a police assistance. You can't go there and push your way into somebody's house to take a person who may be your biological child. So that is my recollection from family court.
I'd still ask you if I know probable cause for a life felony burglary with an assault and battery for trying to obtain her child who she has legal authority to have.
I understand it may seem very unjust, but based on the four corners of the arrest affidavit, there is probable cause for a burglary with an assault or battery. Would a jury convict her of it? A life felony on this charge? I don't know. I hope not, personally.
And I'd ask you not to hold her on the state's motion for pretrial detention.
That is a little different. This is a probable cause hearing, and there is probable cause. I am a judge required to follow the law. The
Judge,
law
you're not
says,
required to hold her. I'm asking you to use your discretion on the motion and not hold Ms. Thurman.
okay, I am holding her.
Yeah, we've heard.
If you're not happy with the court's ruling, please file an appeal. And if I'm making an error, I'm sure the appellate court will be prompt in issuing an order to release her. She's going to have a hearing Monday before the division judge. That judge can readdress her custody status. That judge can also will set a final hearing on the state's motion for pretrial detention. From just so I'm reading this, just so you know, it says here she's homeless, and I'm sorry to hear that. And she showed up at the victim's home with a man, and it sounds like there may be an open DCF case, although it wasn't written here. Anyway, it's no bond.
Wow. Well, that was fun. That was Stu R. I just kept getting stuff coming in. I think I need to close it down here. We've gone on forever. Biggin is doing a stream, but late. I don't have enough to carry over till then. I need another 20 minutes, and I don't have it. This stream was all over the place. All over the place. We had a spider bite. We had a PPO nuked in the middle. We had a woman in what was she, a Kalamazoo council member? Oh, he's on now? Oh, well, wait. Let me fix this then. Let me fix this. All right, there you have it. Long happy hour stream. I think I added it. If I messed it up, I don't think I did. I think I've got the redirect here. But behave yourselves. I think I'm sending you over to Biggin. If not, he's already started. So head on over there if you're interested. Thanks for coming out. I'll see you soon.